Hi, everybody. Let's talk about intellectual property. So, I asked you to read Doris Silk v. Cheney's Brothers, and the question I have for you, the first question is, what are they fighting about? And if you think about it, what they are fighting about is what sticks are included in the bundle that we're going to call property. Does Cheney Brothers have the stick of preventing Doris Silk from copying and selling the patterns that Cheney Brothers is putting on silk fabric? Now, to think about this, right? First, let's ask what would happen if Doris Silk snuck into Cheney Brothers' warehouse and took bales of patterned fabric that Cheney Brothers had made and sold it? Right? Would that be a conversion of Cheney Brothers' property? Right? That's a pretty easy question. The answer is yes. So you have to think about what is different about copying the patterns onto other pieces of silk and selling that. Because it's that difference that leads to a different answer in this case. So in the hypo of sneaking into the warehouse and taking the fabric that Cheney Brothers has printed its patterns onto, right, Cheney Brothers can no longer sell that fabric because Doris Silk has possession of it and is selling the physical objects. That's clearly a conversion of property. But in the real case, Cheney Brothers still had all their silk and they could sell it if they could find a willing buyer. What they're asking is for the court to increase the the pool of willing buyers for their Cheney Brothers silk by preventing anybody else from filling buyers' wants and needs. And that is the key difference. Intellectual property is non-rivalrous, meaning that it can be used by more than one person at the same time, which is very different from the carcass of a fox or a whale or land in many cases. Right? Where possession by one person excludes possessions by others, then you have to make a choice. Who will possess this? But for intellectual property, you don't necessarily have to make that choice because Cheney Brothers could possess and use their design at the same time that Doris Silk was using the design. So what Cheney Brothers was trying to get the court to say is, yes, that stick of the right to exclude others from using is part of what you own by making this pattern fabric. And the court says no. So why does the court say no? Right? The court says no from a vision that is rooted in institutional competence. Like, whose job is it to make this decision? And in particular, whose job is it to make the decision because this is about granting a monopoly? So in Doris Silk v. Cheney Brothers, the court says that it's up to Congress to do that. Right? And notice how Learned Hand distinguishes precedent in this case. Because there is a case, the INS News case, that could easily have justified a ruling for Cheney's Brothers. But instead, Learned Hand says, well, that's about news. This is fabric, totally different. So, one of the ways that courts distinguish cases is by limiting them to their facts and saying, well, that was about the facts of that case. These are different facts, so that rule doesn't apply. So you have to think about what theories of property are advanced by ruling in this case. So if the court were to rule for Doris Silk and say that they could freely copy the pattern, which is in fact what they did, what theories of property are advanced? And of course, the one that the court talks about is utilitarianism in the form of the benefit to consumers from competition and cheaper products. Um, and, probably the court isn't really engaging with social peace and order or civic republicanism or personhood in this particular case. But I want you to notice that this case in some ways is like State v. Shack in the sense that the court is defining the boundaries of property rights. Just like in State v. Shack, nobody was saying that Tedesco did not own his farm. Nobody here is saying that Cheney brothers don't own the patterned silk they are selling. The issue is what consequences flow from that ownership, or if you like, what sticks are in the bundle of that ownership. Both Tedesco, the farmer in State v. Shack, and Cheney brothers still have the stick of right to exclude. It's just differently configured than they were asserting that they owned. So let's say the court had ruled instead for Cheney brothers. What theories of property ownership would be advanced if the court had instead ruled for Cheney brothers? What would they have drawn on? Probably they also would have invoked utilitarianism, but a different part of it, right? The incentive to create that is embedded in the constitutional grant of copyright or patent in the first place. Maybe they would have talked about personhood and the sort of the imbuing oneself in one's creation. But it really leaves us to the question of, is this fair? Should the law allow Doris Silk to essentially steal Cheney brothers' work? And, Learned Hand is grappling with that. He says, well, it would seem as though plaintiff has suffered a grievance for which there should be a remedy. Right? So why isn't there? And it brings us back to the central question of what is this rule trying to accomplish? And what we're seeing here is the court, first of all, saying, hey, it's not up to us. Congress should make this choice, but also recognizing that what has to happen is a balance of making sure there's an incentive for creators to create by granting them some kind of ownership interest, but balancing that with the consumer's interest in affordable prices from multiple vendors. So it's sort of a competition of different utilitarian visions. And I just want to point your attention to the Chanel quote on page 218, which says, quote, "The copyist, albeit unintentionally, serves an important public interest by offering comparable goods at lower prices." So that is always the tension when you're talking about a monopoly, because a monopolist can set the price. So we talked about that in the context of Johnson v. McIntosh and what consequences flowed from ruling that the indigenous tribes could only alienate their land to the United States, right? As the monopoly purchaser in that case, the United States could set the terms. Here, if the court had recognized Cheney brothers as having a monopoly on the designs, then Cheney brothers would get to set the terms of commerce. And that happens quite a bit when you have a patent or you have a copyright. But what the court is saying here is that because there's nothing explicit giving this particular monopoly right to Cheney brothers, we as a court don't feel like we're empowered to do that. And in fact, that should come from the legislature, which has the constitutional authority to grant to creators monopolies in their work. And just a reminder, right, this is what the Constitution actually says, right? Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So again, what we're fighting about in this case and in the other cases is, what are the contours of that? Which sticks are actually in that bundle of exclusive right to their respective writings and discoveries? And Eldridge v. Ashcroft, a case that you didn't read, there was a challenge to what was called the Sonny Bono Copyright Term Extension Act that extended future copyrights for 20 years to the author's life plus 70 years and delayed for existing copyrights the public domain status for 20 years. Now, Justice Breyer dissented in that case, and in dissent, he wrote, and this is a quote, "The Copyright Act exists not to provide a special private benefit, but to stimulate artistic creativity for the general public. It does so by motivating the creative activities of authors through the provision of special reward. The reward is a means, not an end. And that is why copyright term is limited. And that's the end, unquote. So again, there's this tension because the goal here is promoting the progress of science and useful arts, not rewarding creators with a monopoly. Rewarding creators with a monopoly is the means by which Congress is supposed to achieve the goal of the progress of science and useful arts. So there's a balance to be struck there, and the balance gets struck in different places at different times. What rationale could there possibly be for extending existing copyrights? Right? That certainly creates no incentive because, right, that work's already been done. And just as a reminder, copyright requires that there be an original work of authorship that is fixed in a medium. And you don't need to register with a copyright office to have a copyright, but registration does allow a copyright holder to bring additional damages claims. So what about something written by ChatGPT? I just want to draw your attention to the fact that the Copyright Office right now is requesting comments on copyright and artificial intelligence. And that if you have an opinion on this, I encourage you to participate. Comments are due by October 18th, 2023. And you can see the website that you need to go to submit your comments. You may remember a couple of years ago, there was a fight over a selfie taken by a monkey that had been loaded onto Wikimedia Commons. And the guy who owned the camera had set it up that allowed the monkey to take the selfie, was claiming a copyright in the work, and PETA sued, arguing that the monkey should get copyright in the work. And the court ruled that copyright could not be held by animals, so the monkey couldn't have a copyright, and also ruled that because the monkey had actually taken the selfie, the guy didn't have a copyright in the photo. So, you'll see these fights, and we're going to see these fights more and more as this new technology that is emerging changes what it means to be an author. So, this is something to keep your eye on.